Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case Aronson v. Lewis. This case was heard in the Delaware Supreme Court, year of 1984. So let's go ahead and jump into some background and then we'll jump into the facts of the case. So to understand what this case is about, we need to know what a shareholder's derivative suit is. A shareholder's derivative suit is a lawsuit that a shareholder of a company can bring in the name of the corporation. So in general corporate law, you have a board of directors, for instance, and those are the people who are making the decisions that are running the company, running the corporation. Then you have shareholders. Now the shareholders don't generally govern the company. It's the role of the board to govern the company. But if a shareholder believes that, hey, this board of directors or this official is doing something a little bit fishy, they're defrauding the corporation, we are losing money because of that, as a shareholder, then what they can do is bring what's called a shareholder derivative suit. Like I said, you're stepping into the shoes of the company and you're essentially bringing that suit on behalf of the corporation. There's a rule underneath Delaware law, Rule 23.1, that essentially says if you're going to bring one of these shareholder derivative suits, you need to first make a demand upon the board to essentially do what you're going to ask them to do in the lawsuit. The idea is that people need to exhaust their intra-corporate remedies before they turn to the courts, right? And so you need to make this demand. Well, this demand, though, it can be waived if, essentially the court sees that a demand would be futile, right? So where's an instance where a demand might be futile? Well, that would be in a scenario where the officers of the board are essentially engaging in self-dealing transactions, right? So they're kind of defrauding the company. It's like, well, there's no sense in making a demand there. The court's going to see through that. Like, oh, there's no sense in making the shareholder make a demand because the official or the officer, they're not going to do anything differently. They're defrauding the company, right? So the demand futility. And that's essentially what this case is about, is the demand futility rule as the exception to Rule 23.1. So let's jump into the specific facts of this case. The plaintiff, Lewis, is a stockholder of Myers Corp. Myers Corp is the company or the corporation at issue here, and he brings the shareholder's derivative suit as a shareholder, right, against Myers Corp. He brings it against 10 of the directors, the board of directors, but at issue mostly is a man named Leo Fink. Now, Leo Fink is an official on the board. He was with the company before it essentially became this company. So he's been with this corporation for a long time through a merger, through an acquisition. And one of the things that he essentially had gotten as a part of his employment deal was, hey, when you retire, Mr. Fink, you're going to get a 10-year consultant package where you'll be a consultant for the company for 10 years. You're not going to have to work a lot and you're going to get a lot of money. And the board goes ahead now and they renegotiate that package and they basically say, all right, Mr. Fink, you're going to be able to do this in perpetuity. We're going to pay you a nice sum of money. We're also going to give you interest-free loans. And that's where the shareholder, the plaintiff, Mr. Lewis, says, this looks like some fraudulent self-dealing. This is wasteful on behalf of the corporation. I'm a stockholder. I'm a shareholder in this corporation. So I'm going to try and enforce the corporation's rights and say, hey, you can't do this, board of directors. You can't deal Mr. Fink like this in a wasteful manner. The guy's 75 years old. He's not really providing a whole lot to the company. He does own a lot of the stock, but you can't just deal this all out to Mr. Fink. And so he brings this shareholder's derivative suit. At issue at this point is whether there are enough facts in the complaint to satisfy the demand futility requirement. Now, the demand futility requirement, like I said earlier, is you generally have to make a demand on the board to do what you want them to before you're going to file a lawsuit. Well, if it's futile, then you don't have to make that demand. And that's essentially what the plaintiff is arguing here. He's saying, I didn't have to make a demand. Obviously there's no way that Mr. Fink and the board are going to do anything about this. They've given him this lucrative, essentially retirement deal, and they've given him these lucrative interest-free loans. Like, they're not going to do anything about it. That's evidence enough. And the court, the Delaware Supreme Court says, sorry, those aren't particularized enough facts to satisfy the demand futility requirement. You need to plead with more particularity. And that is the key to take from this case, is that if you're going to bring a shareholder's derivative suit and you're going to not make the demand and plead demand futility, then you need to, in your complaint, includes sufficient facts to plead with particularity the alleged, essentially, impartiality of that officer, of that board, and that even if you make a demand, they're not going to do anything. So there's a nice quote, and this is really what you'd want to highlight or what you want to pull from this, where the court says, "Our view is that in determining demand futility, the Court of Chancery, in the proper exercise of its discretion, must decide whether, under the particularized facts alleged, a reasonable doubt is created that the directors are, one, disinterested, and two, the challenged transaction was otherwise the product of valid exercise of business judgment." So this invokes the business judgment rule, which generally just means that there's going to be a presumption that business decisions are valid, they're made in good faith and honest, and we're just going to presume that, and someone who brings it has to essentially rebut that presumption. So they're saying you got to rebut that presumption, you got to plead enough facts to show that this really wasn't an arm's length transaction. These parties are not disinterested. There is some collusion going on. There's a little bit of bad faith, essentially. Those are the facts that you have to plead to bring a shareholder's derivative suit, right? So essentially, the Delaware Supreme Court is raising the hurdle here. They're raising the bar to bringing a shareholder's derivative suit. And in a sense, you could think of this case, although it's long before Twombly or Iqbal, as the Twombly or Iqbal of shareholder derivative suits, right? We're raising the bar. We're saying you have to plead with particularity. So, what might be the implications of a rule like this? Well, first off, and probably most obviously, we might have less cases brought, right? We might just have less lawyers that are willing to bring this case because they know it's going to take a lot more work to essentially mine out those facts that will give them the ability to plead with particularity in their complaint, right? So that's the one downside to this. Now, the upside, I guess, and this is ultimately what the Delaware Supreme Court saw, was we don't want a bunch of frivolous shareholder derivatives lawsuits. Like, if people are going to bring them, they need to be meritorious, they need to be legitimate, and we're not just going to let people, chuck a bunch of things at the wall and get into discovery and then see what they can do. These shareholders have access to certain documents and materials as shareholders, and if that's what they want to, if they want to bring a lawsuit, well, they can get access to those facts and they can plead them with particularity in the complaint, so that we don't have a bunch of frivolous lawsuits. So that's the case. Like I said, largely about shareholder derivative lawsuits, and the business judgment rule is discussed there as well. Thanks so much for watching. Hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.